Watching already. Hello. Are we on now? We good to go? Sorry, I've been.
No,
We
it's
good?
me. It didn't go live. Hold on. Let's do it again.
Yeah, I don't know what happened. Sorry, guys. Ryan's still looking at something. They're saying I'm on, Ryan. JB Pritzker, you in there?
You are live, Tom. Go for it.
Okay. Good morning, everybody. 7 o'clock. I've been up since 2. Ryan woke me up. So, about last night, 11:30 or so, we got the order from the appellate court. The order, if you're not a lawyer reading it, you're like, what does this mean? I'll try to break it down in lay terms as simple as I can for you. What it means is J.B. Pritzker asking them to overturn Judge Grishow's temporary restraining order was denied. His we're going to seek an immediate appeal with all diligence or whatever it was he was saying. They said no. So her restraining order is still in full force and effect. And you know what I like before I get into the details about that restraining order? You know what I like about it? She finds that J.B. Pritzker was engaging in some pretty inappropriate conduct. That his executive orders 24 and 25 were issued for the purpose of violating your due process rights. That's a pretty significant finding on the part of the court. Finding that the executive officer intentionally engaged in violating your due process rights? Isn't that interesting? So nonetheless, the appellate court denied. And there's a couple of things I want to point out to you about the denial that I think are important. They say the issue's moot and etc. Don't get caught up in all of that. I mean, that's in an interlocutory or a temporary ruling like this. That's really not the takeaway. I got a couple of things I want to talk to you about in the order. Because if you all recall, let me find it on my page. Okay, it's on page 5, paragraph 15. So, remember J.B. Pritzker yesterday was saying, well, after they suspended the emergency rules, the JCAR committee, well, it doesn't matter that those rules are suspended because my executive order is still in effect. And so you still have to require masks because of my executive order. Remember that? Let me read to you what the appellate court said. They didn't rule on it necessarily. They didn't have to. Let me read to you what they said. In response to this, because the court asked us, in response to the court's inquiry of how JCAR's February 15th suspension of those emergency rules affected the appeal, the state defendants, which is JB for the most part, in essence argue that the now expired emergency rules were not necessary to effectuate Executive Order 24's definition of modified quarantine. So what JB was saying to them is, irrespective of the emergency rule, my executive order is in effect and they must follow it. You know what the appellate court said? They disposed of that in 2 words. We disagree. We disagree. And then the court points out Executive Order 24 was only issued after numerous courts had found that masking exclusion from school were forms of quarantine, warranting protections under Section 2 of the Department of Public Health Act. His executive order was trying to get around the law and the court and due process. So the appellate court said, no, we disagree. What that says right there, you guys, is what I've been saying to you for months. His executive orders are just fear-mongering. They're hollow policies. And without any lawful rule, not just any rule, a lawful rule or some mechanism, you can't do anything with them. It's just a piece of paper. That's what the appellate court said. Okay. So another thing that the appellate court pointed out, which is what you're all blown up about, well, we still got the Chicago public school system. We still got U46. We still got Decatur. You're going to have to take it to them, because let me tell you what game they are playing. You ready? Where the appellate court says we note the language of the TRO. So all the appellate court doing here is just pointing out what the TRO, Judge Grishow's TRO, it's her order. She decides what it says and doesn't say. The appellate court just pointed out it doesn't restrain school districts from acting independently from executive orders or the IDPH. That is absolutely true. The executive orders and these IDPH guidance, whatever you want to call it, does not do anything to the independent authority of school districts, whatever that authority might be. But Judge Grishow's order is clear that independent authority does not give them the ability to violate the due process rights of students and educators, staff. They cannot use their independent authority to do whatever they want, which is what they're going to tell you. There's already news agencies across this state who don't know what they're talking about, saying, well, the appellate court said that Judge Grishow's order says that they have independent authority. Meaning they can do whatever they want. It doesn't say that. It doesn't say that. It says, her order says that they still have to follow the law, the Department of Public Health. Because think about that. If J.B. Pritzker and the Department of Public Health have to follow due process, the school district has to follow it too, okay? So we're still going to have to deal with those school districts. And we are. Let me give you an example. The Chicago public school system, I have 8 children for now, but there's more coming, that they're trying to say you still have to wear a mask. You still have to wear a mask. I filed a request for contempt on behalf of my clients, Judge Grishow, and in an hour she signed that order of contempt saying that next Friday the 25th they have to appear in court and explain to her why they're not in contempt. Now, do you think if Judge Grishow intended for school districts to have whatever authority they thought that they could have, that she would sign a contempt order and make them come back to her court and explain what they're doing? It doesn't make any sense. But here's where we're at with that, guys. You're still going to have school districts. I hate to say it. I don't like to get into the politics, but these left-leaning districts that are run by the teachers' unions are still going to say that we have the authority. They're going to put your feet to the fire and they're going to make you do something. So, the cases that we have, they're not over. They're not over. We still are going to have to push these cases through all the way to the end to get a final ruling. We're going to do it. We have other cases that we're bringing because many of you have asked to file new cases. We're going to do it. We're going to file contempt petitions for school districts that don't want to listen to a court order. And we have the joinder going where we have a lot of parents saying, I want to join because my school district is still being complicated. Those issues now are just as important as they ever were, especially now that the appellate court has tossed J.B. Pritzker's arguments out. So we're really just dealing with our school districts right now, okay? Hope that makes sense to you. So, again, a couple of things I want to leave you with. As to the issue of the joinder, of wanting to join on with the other parents in these existing cases, that's still something you can think about doing. You don't have to call me. You don't have to use our system. I want to make that clear. Nothing that I'm saying here suggests that you have to ask us to help you with that. There's other lawyers that can help you with that. I would encourage you, if you think they can get it done for you, go ahead. But to the extent you want us to help you with that joinder, so you, again, if your school district's still saying, well, it only applies to the kids in the case, you can join that case still. We have a hearing next Friday on the 25th. Not only are we seeking the order against the Chicago public school system for our clients, this issue of joinder, where all of these other parents and students can join these cases, that's set for next Friday the 25th too, okay? So if you are interested in wanting us to help you, we'd be glad to. Ryan will post the link again on the page for how you can go about trying to join. And again, if you get joined into the case, again, through us or otherwise, and then the court enters an order that you are a part of that case of those school districts, your school district then won't be able to force your children to mask, or if you're an educator, force you to mask or vaccinate or test. Okay. So we still have to keep that stuff going, and we have to finish this through to the end. And again, if you have a school district that is not a party of any of these cases, you have to decide whether or not you want to bring an action against them. Okay. I mean, you just have to make that choice. And again, there's plenty of lawyers out there that'll help you. If you want us to help you, we'd be glad to. So that's going on. I don't know if Ryan wanted me to point it out here, but I'm going to. Here in the very near future, we've got the issue of the buses, right? The buses, where most of these school districts are saying, well, we've got this CDC order. Guys, it's not lawful either, in my opinion. Take it for what it's worth. You know, that CDC can't force your children to wear a mask on a bus in Illinois. So to that extent, if you feel that you want to fight back against that, we are going to offer the same similar type of opportunity for parent groups to get together and to bring actions against their school districts. I hate to say it, but I mean, I don't know what else to do to get these school districts to just take the mask off these babies and leave them alone, right? I know there may be other attorneys in the state that may want to help you do the same thing. I encourage you to talk to them. Again, you don't have to call Tom. Those men and women are just as capable of me. I'm not suggesting I have any more talent than they have. But if you want our help to deal with this issue with the buses, that information is going to be rolled out really soon here about how we can help bring that, you know, and we'll get rid of the masks on the kids in the buses. At the same time, we're still dealing with these school districts that are wanting to be difficult, because as far as I'm concerned, JB, for now, he's out of the picture completely. Okay. It makes sense. And I'm going to have a big event in Springfield on February 28th with some announcements that we're going to make. And I'd also like to have that be a part of a celebration. So there's going to be details coming out soon where I want, you know, I've got some of the kids coming that have been a part of this, and I've gotten to know along the way, that are going to say a few words about how their experiences have been the last year or two. I'll get the details out, but I'd love to have as many of you come. I want to see your kids. I want to talk to them and be a part of this. I'll get you those details out there. But in the meantime, like I said, the appeal was a big deal. And again, the appellate court told JB what we've been wanting them to tell him is now, not anymore, Governor. So we'll see what he has to say today. I hope he doesn't do more gaslighting and more spin and trying to do, you know, make it more confusing and complicated for people. You know, it's sometimes you just got to man up and say, hey, it's over. I lost. That's what I'd like to see him do. But, you know, we'll see what happens when he says something. But that's what it is, guys. And I'm going to keep working now here this morning. It's about 7:15. Look for that stuff on the bus if you're interested. If not, like I said, call my colleagues that are out there. They can help you too. We'd be glad to help you if you want. And have a good day and enjoy yourselves. Y'all been a little nervous waiting for that opinion. Okay. So have a good day. Love you guys. Take care.